हेलो एंड वेलकम इन माय यूट्यूब चैनल एक्सप्लेन। अपन इस वीडियो में डिस्कस करने वाले हैं सेपरेशन ऑफ पावर। बट बिफोर वी स्टार्ट यू हैव टू डू वन थिंग इज दैट यू हैव टू लाइक शेयर एंड सब्सक्राइब दिस वीडियो. So we will be going through the introduction, meaning and definition of doctrine of separation of power, and we'll look basic principle of the separation of power, that is upon what principle the separation of power is based, and the separation of power in relation with the Indian Constitution, that where it has been provided the concept of the separation of power. And we'll look cases that explain the separation of power in context with India, and finally we will land upon the conclusion section. So introduction. Now it become important to understand what is government, because it is a government under which the separation of power is implied, be applied. So government is an agency or machinery through which the will of the state is formulated, expressed and realized. Now it's also become necessary to understand what is the will of the state. Will of the state is laws that is made by the parliament, what we call the legislative body. Now if the lawmaking power is vested in government, then the power, it can be said that the power rests with the government. Now it is honors and duty of the government to protect and act as a guardian of the citizens' right, and right of life and liberty, and right of speech and expression, various rights provided or inherited by birth, that are natural right, or by any statutory right that is given to any citizens. It is a duty of the government to protect that right, not only through the external threat but also through the internal threats. Now it is necessary, and we often had heard that when the power is given to any one body, absolute power is given to any one body, that power is applied beyond the limit. So the line is said that power corrupt and absolute power corrupt absolutely. This principle is not applicable to man only but also the institutions, whereas even government institution or private institution it may be. Now the concentration of power and the authority is degenerate into corruption, abuse of powers, and finally turns into tyranny. We know that the function of the state for all practical purposes are performed through the three branches, that is legislative, executive and judiciary. All three branches have its own independent importance into their spheres, so one should not override or control the others. Each branch of the government should be made independent of each other. If we go through the meaning and definition of doctrine of separation of power, we know that the government has a three organs. Sorry, state has a three main organs of the government, that is LEJ, that is legislative, executive and judiciary. According to Montesquieu separation of power, all the organs of the government should be separated from each other. Their power and functions should be clearly distinct and different from each other, and no one or two organs should interface or intervene in the sphere of the others. Thus it can be said that legislative should not interfere in executive or judicial body, and judiciary shall not interfere in the legislative and executive body. Basically, the story starts from the Montesquieu. He was a French philosopher, and he was positively influenced by the idea of the John Locke, who was a British philosopher, and the working of the British government. Montesquieu found that the Lockean idea of the limited government that was practiced in British were find very useful and very pragmatic type of government. So, and Montesquieu was negatively influenced by the French government under the King Louis XIV, where the power was centralized and king was oppressive and despotic condition that people are not enjoying their full liberty. Montesquieu in true contributed a new idea of the doctrine. Now it is also also important to understand that what is a limited government. Basically, John Locke had drawn a contract between the citizen and the government. In this contract, all the rights of the citizens were transferred to the government, and three rights were not given to the government. That was the right to life, liberty and property. Life, liberty and property were the three rights that were not given to government, and except all the rights were given to the government, and in consideration government has to protect their life. This was a concept of the limited government, and in limited government was made accountable for his act. If government does any wrong, government has to be responsible and accountable to its citizen. If the people would be not satisfied, if people will not be satisfied with that working of the government, people could dethrone that government. This was right given in the concept of the limited government. He emphasizes certain element in that had not previously received such an answer, particularly in relation to the judiciary, and he accorded the doctrine a more important position than did most previous writers. However, influence of the Montesquieu cannot be ascribed to his originality in the respect, but rather to the manner and the time of the opening of the doctrine's development in his hand. Now, there was a Judicial, one philosopher who explains the separation of power in his own words. It was like the separation of the theory that the function of the government should be performed by different bodies of persons, and each department should be limited to its own sphere of action without encroaching upon the other. That it should be independent within the sphere is called the separation of power. The term separation of power originated with the Baron de Montesquieu, a French philosopher, as earlier mentioned. In his book Esprit de Lois, the spirit of what we call spirit of law, this was written in 1784. He wrote, in every state there are three kinds of power: legislative power, here he describes the function of the legislative power, the power executing matter falling with law of nation, and the power executing the matter which fall within the civil law through the first is mean legislative. The prince of magistrate at that time were used to make the law. That's why he used the prince of the state makes the law of the time being for all time, amend, repeal those previously made. It's mean that the prince of magistrate was given a power to amend, repeal, and he had the power to repeal any act and could amend which has been previously made. This power was given to the legislative power, that under the power was granted to prince of magistrate. And the second body is known as executive body. He described through the second power it make war and peace, send and receive ambassador, establishes order and prevent invasions. Through the now he described the third. Through the third, it punishes crimes and judges the dispute of the private individual. That the last is called the judicial body. Now, if we look on the principle of the theory of the separation of power, that is upon which the principle the separation of power is based. What influences the separation of power in this slide we are going to look. Its separation of power said there should be no concentration of power. The theory of separation of power is based upon the principle that the power should not be in one body or group of body, but it should be distributed among the bodies with the proper demarcation of the power and scope of the function. Neither concentrated power would turn into tyranny, it is autocratic government. Second, he says the principle said that there should be a diffusion of power. That the separation of power implies that power should be diffused to have counter balance and harmony. That between legislative, executive, and judiciary there should be a diffusion of power. Mean some power given to the judiciary, some power should be given to the executive and judiciary, executive, and legislative. There should be a diffused power, not absolute power should be given to them. System of the check and balance. The principle check and balance works as antidote to despotism. And this means that executive organ vested with some control over the power of the legislative and judiciary vested with some control over action of the executive and legislative, and last legislative vested with some control over the power of the other two organs. Now, what is the separation of power in context with the India that has been given in our constitution? Now, it is important to note that in India the doctrine of separation of power ostensibly not mentioned in constitution. It means that mentioned in Indian constitution. It means that it is not clearly mentioned in Indian constitution. That if you go through this article, you will find that this separation of power is mentioned. As case in of USA, UK, and France, it is clearly mentioned separation of power, but not in case of the India. It is not clearly mentioned separation of power, but in India, from the various provisions, it means various provisions mean through the, if we go through the various articles, it can be inferred that there is a separation of power to extend in diffused form, but not absolute form. It means there is a diffused form, not a completely. We cannot say there in India there is a complete separation of power. In Part 4, under the directive principle of the state policy of Indian Constitution, it is clearly laid down Article 50 says that the separation of the judiciary from the executive. It means that there should be a difference between power of the judiciary from the power of the executive. The state shall, it means that the state shall take the step to separate the judiciary from the executive in the public service of the state. Article 122 and Article 212 provides that Parliament and the state legislature, Parliament and state legislatures, that the proceedings of the action of the board cannot be subject to any legal proceedings in the court. This article recognizes the independence and immunity of the legislative organ. It means that if any act performed by the MPs or MLAs into the parliament, in parliament or state legislative body, any person cannot bring suit against them into the in the judiciary, because Indian Constitution grants them immunity from any legal proceedings. And if we go through the Article 121 and 211, judicial conduct of the judges of the Supreme Court and High Court cannot be discussed into the Parliament and state legislative body. That if any action taken by the judges of the Supreme Court or the High Court, Parliament cannot take that topic into the in Parliament to discuss upon that actions. Article 53 and 154 provide immunity to executive body, that is if executive head of the union, that is president, and the state, that is governor, the president and the governor are provided immunity in the matter of this civil and criminal cases. If we go through the legal cases in India that explain the separation of power, there has been a number of cases in context with the separation of power regarding the separation of power. And the court upheld the resemblance judgment that there is no clear provision. It's mean there is no clear provision regarding the separation of power in India as other countries like the USA, Australia, and France has. But certain provisions make it that there is an implied form of the separation of power which is diffused in one another. Implied forms of separation of power, like Article 15 provide immunity to judiciary. Article 122 and 212 provide Parliament immunity from the any judicial process, and Article 121 and 211 provide Parliament even from any judicial conducts, and Article 53 and 54 provide executive body as immunity, provide immunity to the executive bodies. So it is an implied form of the separation of power, not clearly mentioned in the Indian Constitution. So in the case Chandra Mohan versus State of UP, the government held that the Indian Constitution, though it does not accept the strict doctrine of separation of power, provide for an independent judiciary in the state, but at the time when the direct control of the executive. Indeed, it is a common knowledge that pre-independence, it means before independent, there was a strong agitation, mass protest, that the judiciary should be separated from the executive, and that agitation was based upon the assumption that unless they are separated, the independence of judiciary as the power level would be a mockery. Mockery, it means it would be a joke. Like in another case, Uday Ram Sharma versus Union of India, Supreme Court held that the American doctrine of well-defined separation of legislative and judicial power has no applicable to India. In case Keswanand Bharti and State of Kerala, Honorable Chief Justice Sikri observed separation of power between the legislative, executive, and the judiciary is the basic part of the Constitution, and this structure cannot be disturbed from any form of the amendment. And this is the last case in relation to separation of power, that is Srimati Indira Gandhi Nehru versus Raj Narayan. Honorable Justice Y.V. Chanchud observed that American Constitution provides rigid separation of governmental power into three basic divisions: executive, legislative, and the judicial. It is an essential principle of that Constitution that provide entrusted to one department should not be exercised by any other department. The Australian Constitution follows the same pattern of distribution of the powers. Unlike this Constitution, Indian Constitution does not expressly vest the three kinds of the power in three different organs of the state. But the principle of the separation of power is not a magic formula. He said that it is not a magic formula for keeping the three organs of the state within the strict confine of their function. So the conclusion from the all slides can can be drawn that henceforth it can be said that separation of power among the organ of the government is indispensable for the running of the machineries of the government. It means indispensable means it is a it can be said that the separation of power is very necessary for running of the machineries of the government, as well as protection of the individual life and liberty and freedom from the tyranny and arbitrariness of any person or body. Separation of power is absolute form is impracticable, and it would be like a watertight compartmentalism of the executive and judiciary. Watertight compartmentalism here, it means that if any water compartment is fully filled, at last it would burst. That what in reference the watertight compartmentalism is used here. In modern world, even USA, England, India and France does not have the absolute form of the separation. Therefore, it is very necessary for the all three organs to have the mutual cooperation, diffusion of power and function, check and balance, and there should be no concentration of power in one hand. Basically, the separation of power expounded by the Montesquieu was very absolute in nature. It was very concrete that the separation of power was very